everyone, today we will do legal dictation exercise number 15. You can get the PDF from description box. So ready? Start. In this case, the appellant's defendants denied having signed, executed any agreement receipt in favor of the respondents. In the examination under Order 10, Rule 2, the court did not ask the second appellant whether he had signed the document or not by showing the document. What was done was confrontation of a signature along without disclosing the document. When so confronted, the second appellant admitted the signature shown as his signature, but that is not an admission of execution of agreement receipt. The specific case of appellants in the written statement was that the agreement receipt dated 7/9/2003 was a clever forgery. If a signature is a clever forgery, there is a likelihood of the same passing the normal scrutiny of the person to whom it is attributed. Similar is the position in regard to stamping the name of the company. If a false signature is very different from the real signature and is easily identifiable, it will be a forgery but not a clever forgery. Therefore, if the document allegedly containing the forged signature is covered in such a manner as to show only a stamp, seal and signature, and if a question is put by the court under Order 10, Rule 2 to identify the seal, stamp and signature, and if the witness identifies the signatures as his and the stamp, seal as that of his company, there are two possibilities. The first is that what is shown is the genuine signature of the party and the genuine stamp of his company, and that he has identified and admitted them. The second is that they are clever forgeries and the party could not obviously identify the forgery when it was shown to him by covering other portions of the document when he is given only a normal glance without an opportunity to scrutinize it properly. Whether it is a forgery or not will have to be determined with reference to the expert evidence and after the evidence of both plaintiff and defendants tested by cross-examination. Both the learned single judge and the division bench committed an obvious error in equating admission of a signature which is claimed to be a clever forgery as an admission of execution of the agreement receipt and the contents thereof. The observation of the learned single judge in his order that the managing director has admitted his signature on the agreement receipt as well as stamp of the defendant number 1 company on the said document, and the further observation that on the basis of the said answer the second appellant could be proceeded under section 195 of Indian Penal Code read with section 340 of Code of Criminal Procedure are without any basis. Equally unwarranted is the observation of the division bench. The managing director of the appellant has denied his signature earlier on the agreement receipt, but when his statement was recorded under Order 10 CPC before the court, an admission came out that the signature were his. The truth emerged, though belatedly. Admission must obviously be a conscious and deliberate act. Admission can be explained. An admission of a signature is not an admission of execution of a document. The power to identify the matters in controversy by examination of parties at the pre-trial stage under Order 10 Rule 2 is completely different from the power exercised by the court under Section 165 of the Evidence Act to put any question it pleases in any form to a witness or a party in order to discover or to obtain proper proof of relevant facts, or the power under Order 18 Rule 14 of the Code to recall and examine any witness. The court's anxiety to do justice by speeding up the process of the suit should not itself lead to injustice. Thank you. Please subscribe my channel Steno Star.